So when business owners are negotiating contracts, they're rightly concerned with things like how much are they going to get paid or how much do they have to pay, things like who's responsible for what and what happens if something goes wrong. And at the end of the contracts, there are several pages of type that usually the business owner says, oh, that's boilerplate. Inside those boilerplate clauses, there is often a clause that's called an assignment clause, which really maybe is better called a no assignment clause. That no assignment clause says that neither party can transfer or assign this agreement without the written consent of the other party. And if you look at the assignment clause, that generally makes sense because you think, I don't want to be in a contract with someone I didn't intend to be. I don't want to be in a contract with a new person that I didn't know about. So let's say that some of your most important contracts in your business have a no assignment clause in it. The issue that comes up on a sale is that in the sale, you're transferring those contracts to the buyer. And so if that no assignment clause says you can't do that, well, now you have a whole new negotiation to open up with the person on the other side of the contract before you can actually sell your business to the buyer. The way that this comes up is in due diligence, the buyer will look through all of the major contracts for the business and specifically take a look for these assignment clauses. For example, for a lot of businesses, leases of real estate are very important, and almost all leases will say that they can't be assigned to a new tenant. Well, when the buyers created a new company for your business, there is a new tenant. And so you will have to go to the landlord to get the landlord's prior approval before selling your business. Oftentimes, this winds up being a last-minute hitch in the sale of the business. And you're in this uncomfortable position where you're not even telling your employees that you're thinking about selling the business, but now you have to go and tell your landlord and try to renegotiate. The issue with a landlord, for example, or anyone on the other side of any other contract, if they know that you have to get their permission to assign the contract because of a sale, they'll often take it as an opportunity to renegotiate and make a better deal for themselves. This also can take a lot of time, which is not the friend of actually getting a deal closed for the sale of a business. The best practice with assignment clauses is when you're actually negotiating the contract to make sure that the assignment clause allows you to transfer key contracts when you sell your business. You might be thinking that a buyer is purchasing the equity of my business, so I don't have to worry about this issue. When you sell the equity of your business, usually all of the contracts of the business go along with the equity because the business remains intact. However, some assignment clauses understand that this is a possibility and say things like the change of ownership of a business is actually an assignment that you need the permission of the landlord or the person on the other side of the contract to approve. The best practice for assignment clauses is to negotiate them up front so that when you sell your business, you automatically have the permission to transfer the agreement.